Thank you all for joining us tonight or this morning, wherever you are in the world, for this Yalla in Focus event. And it is my pleasure to introduce you all to Hasmik Galstyan, who is not only today's speaker, but is also my colleague at AUA, at the AUA Papazian Library. And today she's going to be talking to us about copyright law in Armenia, limitations and exceptions for libraries. And this is especially timely because if you know, yesterday, April 26th, was actually World Intellectual Property Day. So this is a topic that is on people's minds if they are in the information world, information profession. And just quickly to introduce myself, my name is Lori. I'm the director-elect of Yalla and also going to be monitoring this event today. I think most of you already know, but just in case you don't, Yalla stands for the International Association of Armenian Librarians and Archivists, and we are an association under the umbrella of the Society for Armenian Studies. Yalla was created to provide a worldwide platform for archivists and librarians working with Armenian collections to network with each other, share information and ideas, and solve challenges, promote issues important to our field, encourage participation and provide mentorship, and uncover, surface, and map hidden collections, both physical and digital. And if you're joining us today, I see a lot of familiar names, but also some maybe not so familiar. So if you're joining us today and you're not a member of Yalla yet, you can go to iaala.org and find out more about us and how to join us. And we would love for you to join us. We're always looking for more people to join this growing network of information professionals and information activists. So, as I mentioned, today's speaker is Hasmik Galstyan, and just to share a little bit about her, since 2005, she has worked as head of reference and circulation services at the American University of Armenia's AGBU Papazian Library. Additionally, she has served as an EIFEL IP coordinator for Armenia since 2006, advocating for fair and balanced copyright laws and promoting awareness about copyright among local and regional library communities. She's participated in numerous local and international conferences on topics related to information literacy and copyright in libraries, and has translated several EIFEL publications, including the EIFEL Handbook on Copyright for Libraries. So this was translated from English into Armenian, and this was distributed widely among local and regional library communities in Armenia. So without further ado, Hasmik, please go ahead.
Thank you very much, Lori, for introduction. And thank you for inviting me to Yalla webinar. Let me share my screen and start my presentation.
Do you need any assistance?
Just a moment, please. How to share my screen?
So at the bottom, at the bottom, there should be a
I click on share the screen, and then I couldn't find my desktop. But why?
Hasbek, if you would like to send your slides to me, I can share it.
Sure, but why I can't share my screen? I hope you gave me permission for sharing the screen.
I think we see your screen now. Oh,
Sorry.
we were seeing your screen, it seems.
My screen.
Yes. Okay, now we see it.
Sorry, once again, let me go to the desktop. Okay, and
I think you should open
yes,
your.
I'm opening. I'm trying to open.
Yeah.
Yes, now, yeah. Did you see my screen?
Mm-hmm.
Oh,
Yes.
thank you very much. Thank you. So, as Lori mentioned today, I'm going to introduce you the Armenian Copyright Law of 2006, and with focusing specifically on provisions about exceptions and limitations. I will introduce also the same provisions from the draft law, because Armenian draft law, starting 2013, it was in revision process. And we decided that it was a good time to intervene and introduce a new proposal to local copyright agency for more exceptions and limitations for libraries, archives, museums, and educational institutions. And by permission of head of copyright agency, today I'm allowed to introduce these new, more expanded provisions because the draft law has been published on the local copyright agency website for further public hearings, discussions, amendments, and we hope that by fall, the new draft law will enter into force, will be adopted. I will talk a little about IFL and Armenia partnership, since I am talking today as IFL IP coordinator. And after introducing exceptions and limitations for libraries, I will introduce also the provisions from Marrakesh Treaty. Armenia, a couple of years ago, ratified Marrakesh Treaty, which contains more expanded exceptions and limitations for blind and visually impaired people. IFL is, I hope you are familiar with this organization. It's electronic information for libraries, an NGO that collaborates with libraries in over 60 developing and transition countries, Armenia included. And IFL collaborates with these consortiums with 4 programs listed in this slide: licensing program, copyright and libraries, or otherwise it's called IFL IP program, open access, and public library innovation program. Very briefly about these programs. Licensing program, each program, by the way, has its coordinators in all these countries who are implementing pilot projects, activities, sharing information, raising awareness about these programs, sharing resources, conducting webinars, seminars, and assisting librarians, library communities to resolve issues with accessing e-resources. We all know that the subscription cost for e-resources is quite high, not affordable for all the libraries. And this program manages to get access to multidisciplinary databases because IFL negotiates for discount prices with prominent publishers and provides access to the library consortiums and libraries in these countries to benefit these multidisciplinary resources. Among them, I can mention EBSCOhost, Taylor and Francis, Sage, and other databases. Copyright and Libraries program, I will talk about this program in my later slides. Open access program, again, raise awareness about open access resources in all these countries, providing them access to open educational resources, open databases, supports these library consortiums to create open access repositories, databases, platforms in their countries. And many years ago, Armenia created open access platform in Armenia. Now it's called ETD database, electronic theses and their databases, that gives access to great number of scientific research output for local community. It may be librarians, researchers, and anyone interested in this research output. And public library innovation program, again, Armenia is greatly involved in this program. It helps local regional libraries to implement projects, improve their services, provide access to electronic resources, provide access to open resources, use new technologies, and help a local community to in their research, in their teaching and learning activities. Copyright and libraries, the main mission of this program is to protect and promote the interests of libraries in copyright issues, preparing knowledge-based librarians in all these countries, how to support these librarians, how to prepare copyright librarians. Of course, IFL has created great number of resources, guides, handbooks, even curriculums for teaching copyright, for raising awareness about copyright, libraries, museums, and archives. And another important mission that copyright librarians are going to complete, and they are completing, is to advocate for fair copyright system and to advocate for national copyright law reform. Of course, these two activities will not be possible to complete, will not be possible to undertake any activities without close collaboration with local copyright agencies. At first glance, it seems that it's not an easy task to do. It requires knowledge, experience, confidence, and time, efforts to start collaboration with local copyright officials, whom, to say honestly, I have never met before. I was working at Academy of Sciences as a cataloger for 20 years, trying to master, understand these mark formats to create accurate bibliographic descriptions of the book. And sincerely, I have never had issues, meetings with copyright experts. But after being nominated as IFL IP coordinator and understanding what great mission I have to complete, I started my collaboration with local copyright officials so that they could hear the voice of librarians and for fair copyright system, for advocating for fair copyright system. Of course, a very serious advocacy campaign was required to start. And with IFL support, we started this campaign in 2013. Conducting several meetings, webinars, meeting with local copyright officials, sharing these resources among library community to understand what is copyright, why do libraries need to be concerned about copyright, and to make our negotiations more productive, more effective, and to listen concerns from various types of libraries and communities. We created Library Copyright Committee, and I'm so thankful to my colleagues for supporting me in this advocacy campaign, for organizing webinars, presentations, and meeting with local copyright officials and clarifying them our general concerns. Because I remember my first meeting with copyright agency, head of agency, he was so much surprised to see that the librarians want to make some proposals and they have some concerns with copyright. His first question was, but why do you need to worry? Just don't copy, don't make illegal copies, that's it. But during our next meetings, they understood that there are so many services that the libraries are providing. And so the out-of-date laws restrictive provisions, not to create barriers for library services. We really need global amendment of the law, and we need to create more exceptions for libraries and educational institutions. Copyright law, yeah, and let me add that during this advocacy campaign, Handbook of Copyright and Librarians was published and distributed for local and regional libraries during the seminars and webinars that we conducted with them, because unfortunately, there was not a single brochure, a single book, any material in Armenian about copyright and libraries. Copyright law is not that easy to understand, especially with librarians without legal professional background. This handbook was a wonderful guide for the librarians to understand library-related issues, copyright issues related to the libraries. And the copies we translated into Armenian and distributed to library communities. Now, briefly about the content of copyright law. Armenian copyright law, like any copyright laws, grants legal protection to the authors, strong legal protection to the authors, protecting their exclusive moral and exclusive economic rights, non-economic economic rights, non-economic rights, otherwise called moral rights to their works. Because from the very beginning, the purpose of copyright law, has been to encourage innovation, creativity, research, and giving strong legal protection to the authors, to their work. This way, the purpose of copyright law was to encourage creativity and innovation. But at the same time, copyright law protects not only the author's rights, but also the user's rights. Otherwise, only the authors would have monopoly of using their works. And this balance between authors and users' rights work and are being enabled through the tools, limitations, and exceptions for these provisions that allows to have this balance, to create this balance in the copyright law. Limitations and exceptions, the important provisions that today we are going to talk, and limitations, exceptions for libraries and educational institutions. Moral non-economic rights of the author, according to Armenian copyright law, is the right of authorship. Any person has right to be recognized as an author and demand the others to recognize him as the author of the work, him or her as the author of the work. The author has right to use the work by his name, by pseudonym, or anonymously. The right of author's reputation and dignity. The author has moral right to protect his work against any violations, infringement. Of course, the severe violation of author's reputation, dignity is when someone uses the author's work without mentioning the author's name, introducing it as his own work. In this case, the user violates the author's right to be recognized as the author, as the creator of the work. So plagiarism is one of the severe violations of authors' moral rights. And at AUA, during information literacy sessions that we're conducting for freshmen and for undergraduate students as well, we have developed a special module where we teach our students how to avoid plagiarism, how to use the information ethically and honestly. So the author has right to protect his words against, to protect his dignity and reputation. The right of first disclosure is another moral right of the author. It means that only the author has the right to publish his work for the first time. The right of withdrawal, it is the author's moral right to take out from circulation, to withdraw the works that he thinks that further circulation of these works will damage his reputation, that these works doesn't comply with his principles, ideas, For any good reasons, he can decide to withdraw the works. If it's works of art, then take them out from public places. In this case, if his book or any printed material has been already published by a publisher, the author must compensate the pricing costs and pricing costs that the publisher has done for publishing the books. This is the author's responsibility. The moral rights are inalienable, non-transferable. They don't have any copyright duration. They exist with the author forever, with the exception of right of withdrawal, because only the author has right to take out from circulation his works, to withdraw the works. And the withdrawal right only runs for the life of the author. All the other moral rights last forever. Exclusive economic rights of the author. These are the rights that give financial benefit to the author. The author has right to allow, to permit, or to prohibit the uses of his works listed below: reproduction, distribution, rental, lending, public display, communication, and adaptation. These are the actions, types of use of the work that needs permission from the author, which is very important for the librarians to do, because the libraries are implementing so many projects. The libraries are using the works from their collections, reproducing, distributing for various activities, and for these types of use, the librarians should know that permission is required. While librarians should be concerned and aware of copyright issues, quite for a simple reason. If copyright protects the author's right towards their work, then libraries are one of the authorized entities that have good collections of copyrighted materials. They are collecting these materials, they are preserving, they are digitizing, they are serving the public. So with great respect to the copyright, the librarians should know also to provide access to these materials for their patrons, users, ethically and honestly. So exclusive economic rights of the author gives financial award to the authors. Copyrighted works, you see the list of the copyrighted works taken from the Armenian law: literary, artistic works, musical works, architectural designs, translations, adaptations. And I would like to inform you, and we inform our librarians as well during the presentation, that they should be very attentive in using the work, because sometimes a work can have several copyrights. If the book has illustrations, diagrams, or it's a musical work, it can have copyright for the text, for the music, for the screen player. And to use the work honestly and ethically, the librarian or anyone who is going to use this work needs to get permission from all copyright holders. A week ago, my colleague approached me saying that they want to digitize a book. And they want to remove the photos, pictures from the book. Of course, they are not allowed to do it, because if the author has permission to publish these photos, illustrations, any third-party copyrighted material in his book, it doesn't mean that he has permission also to allow anyone to digitize this book. So third-party copyright clearance is very important for librarians to consider when using the work. Non-copyrighted works. Here are the list of works that are not copyrighted. The work to be copyrighted, I forget to say, the first condition for the work to be copyrighted, it should be creative, unique creation, and fixed in a tangible medium, either recorded or printed. This is the requirements for the work to be copyrighted. The work is copyrighted as soon as it's created and as soon as it's fixed on a print, on any medium perceivable for the public. Copyright registration is not mandatory according to Armenian law. The author doesn't need to register his copyright. They can put a copyright sign on the book just for notification that this work is copyrighted. But they can register their copyright if any legal issues, if any disputes during legal proceedings, to have alibi that they are the author of this work. If any problems with ownership, authorship, in this case, maybe registration will be very beneficial for the author. And in Armenia, we have collecting society, Arm Author, where the authors can go and register their copyright. So copyright is for only these cases and for notification, but registration is not mandatory. Non-copyrighted works are listed very accurately in the Armenian copyright law, works of folklore, daily news, current events, official documents, composed by government employees within their main job duties, political speeches, ideas, principles, methods. No idea, no principle, viewpoints can be copyrighted because they are not fixed on tangible medium. And of course, works in public domain. I will talk about public domain in my next slides, but let me say that the works in public domain are the works when copyright duration is exhausted, and after 70 years, the work becomes public domain work. Copyright doesn't exist forever, and it is limited authors' exclusive economic rights. Of course, moral rights, they have no copyright duration. Economic rights are limited in two ways. Term of protection is the life of author plus 70 years after his death, and upon expiration, the work falls into public domain and can be used freely. And exceptions and limitations. By these provisions, again, authors' economic rights are limited. So the exceptions are given to certain economic rights of the author and provides limited use of copyrighted works by libraries, archives, and any authorized entities. The limitations apply in certain special cases. This is a three-step test from Berne Convention, and Armenia is a member of Berne Convention, and the exceptions and limitations exist in copyright law and can function properly only thanks to these three-step tests. Due to three-step tests, it means that limitations apply in certain special cases. Limitations when the authorized entities, persons, can use the work without author's permission. These special cases should be not for non-profit, educational, fair purposes. And if another condition, another step to when the limitations should apply, such use of the work will not conflict with a normal exploitation of the work. What is normal exploitation of the work? Of course, if a library copies the book in many copies and distributes among the users, students, and anyone who has requested it, it cannot be considered normal exploitation. Shortly, if the book is on sale and the library can acquire it lawfully, then in this case, better to avoid copying and distributing the book to the users. And the third important condition, the use of the work does not should not unreasonably prejudice the legitimate interest of the author. Of course, with illegal use of the works and distributing these works will not allow the author to get financial award of his works, to be able to control the use and distribution of his works, and his economic and moral rights will be violated. Now, I mentioned in my first slide that I'm going to introduce also some provisions from the draft law. Now, in our draft law, fair use factor has been incorporated, added. Fair use factor is much more broad interpretation of three-step test. And the limitations should apply according to three-step test in accordance with fair use factors. Here are four fair use factors. Again, the purpose and character of the use is very important. If any disputes, again, if any legal proceedings, jurisdiction will pay attention to the purpose and character of the use. Of course, it should be for fair purposes, for non-profit, for educational purposes. The nature of the copyrighted work, again, is very important when at jurisdiction, at legal proceedings to consider when using the copyrighted work. The more creative the work is, the more it is protected. Why? Because we know that copyright law encourages creativity, innovation, research, and that's why the nature of the copyright work, the more it is creative, the more, the strongly it is protected by law. For example, a whole music, literary work, works of art, they will be strongly protected by the copyright law. So the nature is very important when considering fair use. And the amount and substantiality of the portion of the take. Amount, of course, the less the better. A small short extract from the work, a few sentences, a small quotation will be much more lawful to use and will skip the user from violation. Unfortunately, in our Armenian law, and I'm not sure whether in any other laws, there isn't a strict proportion how much is less, how much can be used. They say less. And sometimes using the small part of the text, it can be substantial part of the work, saying that maybe a few sentences or a short extract from the play, from the work, may convey the whole plot, the heart of the work. In this case, we can't say that less is much more better to use. Again, this is for lawyers, experts to pay attention how substantial is that part for certain work. And the effect of use upon potential market, again, if the work can be purchased, can be acquired lawfully, better not to copy and distribute the copies to the users. These four factors are new provisions incorporated into Armenian law. Now, free uses where the work can be used without author's permission, without remuneration, but by mentioning the author's name and source of the work. Of course, by making quotations, for scientific research purposes, use of works of literature, art, extracts by illustrations in educational publications, reproduction of political speeches, lectures, again, pay attention to the extent justifying the purpose and information. Parody, caricature, provided that this use will not create confusion to the source of the work, will not violate the author's right, will not have negative effect on his reputation, offensive, malicious effect on his reputation. And reproduction of articles, short extracts for the study and research. Again, another limitations for libraries. The libraries are permitted to reproduce the works for purpose of preservation or restoration. The book is damaged, they can reproduce a work for preservation purposes. By the way, the previous law, the old law, 2006, allows only reprographic reproduction. But upon our proposal, we suggested to considering the modern services, modern technologies that the libraries are using, to allow libraries to have electronic digitized copies of any material for preservation and restoration purposes. The libraries are allowed to make the work available to public through dedicated terminals. Those terminals located in the library premises, again, for research and private studies. The libraries provide copies to each other by mail, fax, electronic means of transmission. This is very required service that the libraries are performing. Not all the libraries can have the books requested by their patrons, and the libraries will be allowed to deliver these documents to each other without author's permission. By the way, in the previous law, nothing is said about interlibrary loan delivery, just lending the copies. And we suggested to include this use as well, interlibrary loan document delivery, because nowadays electronic transmission of documents is much more effective and very actively used. Reproduction in Braille, we will talk about Braille later, according to Marrakesh Treaty, which gives more expanded provisions for reproducing the work for visually blind, disabled people. The previous law has only one small provision, just transforming, reproducing the work in Braille for visually impaired people. And public performance of musical works at educational institutions for educational activities. But with one condition, that the participants, attendees should be students, staff, faculty, persons affiliated with the same university, institution, or any other establishment. I remember during Amical Conference, or General Assembly of Conference in Armenia, Bella will remember, during lunch we were to perform some video clip for the participants. We have guests from many countries, maybe 90 participants, and we asked the author's permission to perform this music during lunch time, and we're happy to get permission from him. Limitations for educational and scientific purposes. Free use, again, without remuneration, should be permitted only for illustration purposes and scientific research, again, to the extent justified by non-commercial purpose, with a reasonable extent, and under the responsibility of educational establishment through a secure electronic network. In nowadays, many universities and AUA as well are using virtual learning environments, Moodle, and all the documents are being digitized and made available to the students through this platform. The previous law doesn't have appropriate provision for digitizing and making available materials through virtual learning environments. And we suggested also this new provision through secure electronic network, where the students have access through passwords to access the educational materials, book chapters, articles, any documents that will be uploaded by their instructors. Public performance of work in the framework of classroom teaching. Again, this is very important for libraries to know, because in the library collections, I hope all the libraries, they have video materials as well, visual materials, and very often the students approach us with this request of borrowing videos and showing these movies in the classroom and inviting their friends outside the university. No, of course they can't. They can show these videos in the classroom for their classmates, for their instructors, but not for public outside. The permission is required in these cases. Public performance of a work at school events with no entrance fee. This is also a new provision from the draft law.
I'm so sorry for interrupting.
Yes,
I just want
yes.
to quickly bring attention to the time, because I would like to leave at least 10 minutes for questions. So if you can wrap up in a few minutes, then
yes, very quickly. Thank you very much. Thank you very much, Lori. Orphan works, these are works when it is impossible to identify the right holder or location is not found. And there are many books, materials in the library where the authors are unknown, because you know that it is the author's moral right to publish the work anonymously. In this case, according to the new draft law, we don't have this provision in the 2006 law, the librarians should perform diligent search before using the work and keep the records of this diligent search, if any disputes, any issues for their alibi, for mentioning the fair use of the work and also contact information of the organization. Again, orphan works can be used for fair purposes, digitizing and cataloging. Marrakesh Treaty, I'm finishing already. As I have already mentioned, Armenia joined this treaty, ratified this treaty 2 years ago, and it gives much more provisions for making the works accessible for visually blind people. Again, only authorized entities can provide these materials, and which is very important and good beneficial provision to have in our law. Cross-border exchange is allowed according to this treaty, because changing the works into accessible formats is time-consuming, money-consuming, and to skip additional costs, accessible formats should be permitted for the libraries to exchange with each other. And if needed, to circumvent also technological measures, because technological digital protection measures are used by authors to protect their works against unauthorized copying, sharing, distributing, but for educational purposes, for providing access to disabled or any other person for fair use, the libraries should be allowed to circumvent technological protection measures, meaning that negotiating with publishers, taking keys, encryption codes, and some tools to unlock digital locks. This is a proposal for amendments in Armenian copyright law introduced to local copyright officials based on the treaty proposal on copyright limitations and exceptions for libraries. Mandatory exceptions, and we are so thankful, happy that they incorporated these provisions into the law. And we hope that when the law enters into force, these provisions will be already approved and amended there. These links that I will share with you will give you more information about DIFL activities, about useful resources, about Armenian law, and also about Armenia's membership to these copyright treaties. Being signatory of this treaty obliges Armenia to have the same protection standards in his country as well. Thank you very much for your attention. Now I'm happy to take your questions. And thank you, Lori, for reminding me about that.
Mm-hmm. Thank you so much, Hasmichan. That was
You are
super
welcome.
informative, super thorough. And we have about 10 minutes for questions, and I see Levon has his hand raised. Go ahead.
Yes, please.
Well, first, Hasmik, I want to congratulate you on clearly discussing a very complicated topic. I was in the United States Copyright Office for 4 years, and some of the lawyers could not be that clear. I just have 2 questions, one theoretical, one inquisitive. In 2012, I inquired, actually, Nersesjan, you inquired for me, because I wanted to reproduce things for my exhibit catalog from Soviet Armenian books. And at that time, we were told that anything before 1960 was in the public domain. Has that changed? Is that still valid in this new copyright law? And has the date changed?
The new copyright law, the protection of authors' rights is 70 years. After 70 years, the work will appear in public domain. But if it's still protected, permission is required for certain uses.
So in other words, that what I was told in 2012 is no longer the case, is what I'm getting at.
Yeah, maybe No, from 2000. Yeah.
Yeah, so in other words, it has been superseded by the author plus 70 years, which is very interesting. The second thing I'm inquiring, you might not have had time to deal with, and I don't know whether the international copyright community has even considered the implications of this. How much copyright protection is afforded to a person who has used AI in the composition of his visual or literary work? Has this even been discussed?
Well, AI, this is a topic not that well investigated. So AI and copyright is a very tricky question. AI materials, they can't be copyrighted because copyright protects the works of humans. If I correctly understand you.
It's true, but
A-
I think, when was it, Nora? Is
Sorry?
Nora's-
Yes,
is-
yes.
Yeah.
We had a presentation where AI was being used to read Armenian palimpsests and to
Yes.
complete Armenian inscriptions. And then presumably, let's say a scholar published, and I'm not asking you for whether it's been decided, I'm asking whether it's actually been considered. If the person then publishes these restored inscriptions and publishes these texts that have been found behind another language, are these to be protected by copyright law?
For me, if he's the publisher of the text, it should be copyrighted. But if simply he needs to mention the source where he has found this information, what tools he has used. But let me check to be more accurate in my
I didn't
answers.
put,
Let me check it with experts and answer you later. If
Thank you.
I will ask you, to send your questions to give you more correct answer.
Yes, well, I won't be
okay.
dealing with this, but I think Lori will, and everyone under my age will. So you don't need to waste time on it. I was just interested.
Well, actually, I wanted to suggest, Hasmik, that please do inquire because I do see a lot of issues, a lot of activities regarding AI. We also
Right.
have a lot of concerns, questions. And so I think it's a good time for also Armenian librarians to start the conversation. It's
Sure,
very
yeah.
important to start as soon as you can.
Yeah,
If I may, I don't know, I have some questions too. Is it possible for me to ask my questions? Okay.
Yes.
The first question is, how problematic is plagiarism in Armenia? Every country, even us, we have issues with plagiarism, but how problematic is that in Armenia?
Of course, it's problematic. And let me bring our experience, how we struggle with plagiarism. At AUA, our faculty is lucky enough to use anti-plagiarism software, Turnitin, and to detect the unoriginal text by students, written by students. I would say that we don't have that much great percentage of plagiarized text in at AUA, but unfortunately in other universities, I can't say what is the situation in other universities, what is the picture, but of course plagiarism is violation and catastrophic for further sustainable development of the country. And I'm not sure. And as I know, Armenians, they are also creating a software, anti-plagiarism software, to somehow stop this violation.
Wonderful. And I have another question also.
Yeah.
So you mentioned about digitization of books for preservation purposes.
Yes.
So what if the book is published outside of Armenia and it falls under the copyright laws of that country that it was published? So in that case, would you also digitize that book for I mean, the book that is under copyright, not the ones that they are open access?
The same rules and regulations work for all the countries that are signatories of these copyright treaties. If this member is also a member of these copyright treaties, and if the certain copyright law of certain country has the provision for preservation purposes to reproduce the whole book, then the libraries can reproduce it. These limitations assume no consent from the author. Without any consent from the author, they can digitize it for preservation purposes. And also they can digitize the whole copy of the book if it's out of publication during the last 2 years.
Well,
this is what we want to incorporate into the law, that for preservation purposes, no consent is required from the author. It doesn't matter for what country is published the book.
Well, I'm not sure about that though.
Let me check it with my experts again.
This is why I'm bringing this up, because that is a very sensitive issue. Thank you very much. Thank you for your presentation.
Thanks to you. I will check this answer. I will be very thankful to you if you send as many questions as you need to provide you with more accurate answers, checking with our local copyright experts. Okay, because as I know, the reproduction is permitted for preservation purposes.
Yeah, thank you. Thank you very much.
Thanks to you. Thanks to you.
Lori, I see your hand raised.
Yes, thank you, Hasmig. That was an incredibly clear, concise, and very informative presentation. So I'm very grateful to you for giving it. My question was kind of about the dialogue between librarians and lawmakers. I know you mentioned early on in your presentation about conveying some of your concerns when these laws were being drafted and people being surprised that, librarians even had specific concerns relating to copyright. So I was wondering if you could tell us a little bit more about that process. How did you gather feedback from librarians to communicate, and also just in terms of the dialogue once these laws are put into effect, how you communicate them back to librarians throughout the country?
Yeah, thank you very much. Thank you very much. My first step after returning from the first Eiffel conference in 2006, my first action was to invite library community and start several presentations, copyright raising awareness seminars, because I see that, yes, this is the fact that the librarians were not aware of copyright issues. And using the words violating the author's rights. These seminars were conducted for so many years for local, regional libraries. I traveled to Gyumri, Vanadzor, Kapan, and shared my knowledge and experience with them. The next step, very important step, was starting collaboration, meeting with local copyright officials. During these visits, I was so thankful to them to spend time with me, understanding our issues that the libraries have, and suggesting reasonable solutions to this or that issue. And after returning from Geneva conference, I was lucky enough to attend WIPO session at Geneva. I organized also a meeting of international experts. Kenneth Cruz and Teresa Hackett invited them to Armenia. We met with local copyright officials, and these meetings were much more productive. They assist both with their competent advice consulting, local copyright agency, and our library communities as well, because they had public hearings and meetings, webinars at university that I organized for other library communities as well. And I think that I can say for sure that these meetings were very productive for local copyright officials as well, for further amendments in the law, because they are experts. They know what we want. It's another case, but what reasonable changes can be made in the law. So they were more competent to advocate for these provisions. So meetings with international experts, I think, was very helpful. And the persons who are drafting the law, it was 10 years, maybe 8 years ago. I organized a meeting with international expert who was drafting our law. Now there are other experts, and still now our collaboration with copyright agency is active, and they are always happy to provide us with competent advice and consulting. The fact that the proposal with these mandatory exceptions and limitations was incorporated in the law, I think this is great success. Maybe some proposals will not be adopted, like term of protection. We were suggesting 50 years. Why to take 20 years from public domain? white for the users, where 20 years for free use. And also they feel not that friendly with this provision of circumventing technological protection measures, because circumvention, bypassing, it sounds a bit illegal, but we're trying to explain that then we don't want to do any circumvention, just have tools to unlock digital locks. This was, of course, a long process. From 2006, I'm just in these negotiations with local agencies, authorities, and they invited the librarians to the general to the parliament during final discussion of copyright exceptions, and also legal deposit copy law, loan legal deposit copy.
Thank you so much. Thank you for your questions. It's 9 o'clock, but or it's the hour is up, but we have one more question left from Camille. If you want to quickly ask your
Sure.
question.
Yes, thank you. So I have a question about nonfiction books, like reference books that were created during the Soviet time period. So if they were created by, I guess, the government in the 1970s, 1980s, would those be considered public domain? And can you digitize those?
Again, they need to check who is the right holder of these books. I think it may be the publisher. We need to check who is the right holder to get permission. It's not
So it
important
wouldn't
that, yeah, and what agreement the publisher has with the author. If the publisher has also economic rights, 70 years, the same duration as the authors. In this case, our negotiation will be with the publisher.
So it wouldn't, so even though it's a book created by the government, it wouldn't be public domain?
Again, we need to check what type of book it is. Yes, government publications, maybe they are not protected by copyright. We need to check it. I haven't had an issue of digitizing these books because we're not digitizing, but it's better to check whether it's government publication, whether it's protected or not. For these cases, I'm always consulting with experts before undertaking any actions, consulting with experts before digitizing it.
Sure. Okay, thank you.
Thanks to you.
Levon, do you want to go ahead real quick? Oh, you're muted.
Just very quick on that last question. If you're following international law, government works are protected within that country, are not protected within that country. In other words, they're free for people in Armenia, but let's say the United States government works are protected by copyright outside of the United States. So perhaps Armenia is, I don't know, but perhaps Armenia is the same in that regard.
Well, I'm not that familiar. I don't know. I don't know whether, because the same work may be protected well, by Armenian law, not protected by the authors. I'm not that familiar with copyrighted works in other laws, but it's not difficult to check. It's not difficult.
Yeah,
to
maybe
check
that's
if,
something we can
yeah,
check and get back.
yeah, before, and in any case, before using the work, it's better to check whether it's copyrighted or not.
Okay, I know there's a lot to unpack with this topic, and maybe we can continue that at another time on another platform. But for now, I'd like to thank you all, and I'd like to thank Cosmic especially for her fantastic presentation. And
Thank you very
all
much
for joining us and for your questions.
Yeah, sorry for the participants if I couldn't very well answer your questions. I will once again ask you to send these questions, and with consulting our local copyright professionals, I will provide you more accurate answers for all these cases, especially AI, copyright, and government publications.
Great. Okay,
Thank you.
with that, I bid you all adieu. Whether you're going into your day or your night, I hope it's a good one, and we'll see you at the next Yalla in Focus event.
Yeah. Thank you very much.
Bye.
Bye. Thank you.